Hi, folks. We've still got a number of people joining us, so we're going to wait a couple of minutes and then we'll get started. Welcome to today's free clinic on Social Security disability benefits presented by Legal Aid of North Carolina. This clinic will explain the different types of Social Security disability benefits, the eligibility requirements for benefits, how to apply for benefits, and what to do if your application is denied, how to prepare for a disability hearing, and the effect of the coronavirus emergency on current and future claims. Our presenter today is Brian Hogan. Brian Hogan is a supervising attorney in the Greensboro office of Legal Aid of North Carolina. He received both his undergraduate and legal education at the University of North Carolina at Chapel Hill. He is licensed to practice law in both North Carolina and California. His primary practice area at Legal Aid is public benefits, and he has been certified by the North Carolina State Bar as a specialist in Social Security disability law. At the end of the presentation, you'll have an opportunity to ask Attorney Hogan general questions. Please keep those questions as general as possible, as we are unable to provide you with legal advice specific to the facts of your case. Thank you for attending today's clinic. And with that, I will turn it over to Attorney Hogan.
Thank you, Blaine. As Blaine mentioned, I'm Brian Hogan. I'm streaming live to you from our Greensboro office of Legal Aid of North Carolina. And this is something a little bit different for us. Usually, Legal Aid of North Carolina holds monthly clinics that we stream to providers throughout the state where people can come and watch and get general legal advice on certain areas such as Social Security disability, landlord-tenant issues, custody, divorce, expunctions. Obviously, right now, things have changed because of the COVID-19 pandemic. And so we're trying to actually do a live video now where we can address COVID-19 specific updates that may be impacting certain practice areas like Social Security disability. So again, just to kind of go over what we're going to talk about today, we're going to do an overview of SSDI and SSI eligibility. We're going to discuss the application process for SSDI and SSI, the appeal and hearing process, and how COVID-19 may be conducting the way you do business with SSA. And also importantly, how your due process rights can be protected if you're involved in this process while there has been disruption to the normal course of business with Social Security. So I'm going to be, and I hope many of you are watching this by video, because I'm going to be going back and forth between my PowerPoint and also my web browser, because I want this to be a little bit more interactive, where I actually show you some of the resources available to you and how to use them, particularly on SSA's website. Before I do that, though, I wanted to just give you a brief update about what's going on in Legal Aid in North Carolina during this pandemic. We are open and fully operational. I did a Social Security phone hearing with an ALJ this morning. We're doing hearings. We're still going to court as well for emergency matters such as domestic violence protective orders. So we are here. We're still answering calls. We're still taking cases. We're still representing our clients. So I want you to be aware of that. I also want to point you to our website. Our website has fantastic resources that have been compiled concerning the COVID-19 pandemic. And I believe that we're going to be doing pretty frequent live webinars like this about various practice areas. And I believe that one that may be coming up is about unemployment benefits, and Blaine may want to correct me if I'm wrong about that. So
we have at least
right now.
2 next week. Sorry,
Okay.
didn't mean to interrupt.
Thank you, Blaine. I appreciate that. And I believe we'll probably have that information posted on our website too. Is that correct, Blaine?
Yep, it's all on the website. It's also on the Facebook page.
Great, thank you. So I want to just show you our website if you haven't been here before. And I wanted to point to the header here on coronavirus. If you click there, there's going to be a wide variety of resources available to you about your rights and about links to other agencies that have information about COVID-19 around, say, utilities, unemployment benefits, things that directly impact your day-to-day life and how COVID-19 is impacting that as well. In addition, I want to point you to ways to get in contact with us before we get into the presentation. So again, we're fully open and operational right now. We are still answering calls on our legal aid helpline. And our legal aid helpline, you can reach us at 1-866-219-LANC or 5262. Again, that's 1-866-219-LANC 5262. And you can also apply for our services online by using our webpage as well. So before we get into the details about particular Social Security disability programs, I wanted to kind of give you a broad overview of the various offices that you may be interacting with if you have already applied for Social Security benefits or if you're thinking about applying for those benefits. So first, in general, the agency, the federal agency that we're referring to is obviously the Social Security Administration. For our purposes today, that's the federal agency that administers 2 cash benefit programs for retirees or people with disabilities. And there are 2 large buckets of 2 containers, we can say, for Social Security benefits. One is going to be what's called Title II benefits, and the other is going to be Title 16 benefits. And more specifically for us, Social Security Disability Insurance and SSI. And those are the 2 programs that we're talking about today, and they are administered by the Social Security Administration. The front line of contact for most people when they're interacting with Social Security are the local Social Security field offices. Now, as of Tuesday, March 17th, all face-to-face service, all in-person service at the Social Security field offices has been suspended. You can't actually go into the Social Security office anymore. In fact, the Social Security offices are operating on a skeleton crew, and most of the agency's employees are working from home doing telework right now. Generally, if you wanted to get in touch with Social Security, the only way to do so other than going to the actual office was by calling their general 1-800 number. Because of that number being overloaded right now with calls, Social Security has released all of the individual numbers for the local field offices. And I wanted to show you how to find that information because this is really important. You probably do not want to call the 1-800 number, or you can try them, but I'm told that it's best right now to contact your local Social Security field office directly. And to find that information, I put the link right here, and I'm going to switch over to my web browser again. So first, SSA.gov, Social Security's website, is an amazing resource. Anything that you possibly want to know about Social Security is there. And kudos to whoever administers this website. It's a fantastic resource. In my practice area for Social Security disability, I use it all the time. And you should too. So here's SSA.gov. And we'll come back to this in a moment, but you can see up top, they have COVID-19 updates. And when you click on that, it goes through day-by-day updates about what's going on at the Social Security Administration in terms of what's happening. We'll go back through that list in a second, but I wanted to point you to a section of Social Security's website. If you go to ssa.gov/locator, you can find your local field office numbers. So here's ssa.gov locator. I click on locate an office by zip. I'm going to put our zip code here at the Greensboro Office of Legal Aid. And this will tell me the local contact number for that field office. Use that number if you're within that field office. So again, you put your zip code in, the field office locator will tell you what your local field office is, and it will give you the direct number. Usually that's not available to the public, and now it is. So in addition, if you have a pending case that is currently at the hearing office, you can also locate your hearing office that way. And I'll go through that in a second. So again, going through all the different offices, we talked about the field office. That's your first line of contact if you want to apply for benefits or if you have other questions about benefits. Another agency that you may have to interact with if you're applying for benefits or you're currently in the application process is DDS, Disability Determination Services. DDS is a state agency that's mostly funded by the federal government, Social Security Administration. And from what I understand right now, DDS is also working from home doing telework as well. The main DDS contact number is listed there, 1-866-542-8113. I don't know right now if it's possible to get through to somebody who's doing telework or not. I did try to call earlier today and I had some difficulty basically getting through to somebody. I was on hold for a period of time, which is not surprising right now. I just want you to be aware of that. Something else that you should be aware of that we'll come back to in a little bit as well is DDS, that's the agency that makes disability determinations at the initial and the reconsideration stages of appeal that we'll go through in a little bit. Now, sometimes DDS will send you out for a consultative examination. They send you out to an impartial doctor for an examination to help aid in the assessment of your case for disability. I understand that yesterday, March 31st, or 2 days ago, on March 31st, the administration posted an administrative letter, which I have not seen a copy of yet, noting that all consultative examinations have been postponed. So I have not confirmed this directly with the NCDDS. I've just heard that the federal agency, Social Security, has asked all DDSs throughout the country to postpone CEs during the pandemic. So if you have an appointment for a CE, you should still first call DDS to confirm that it has indeed been postponed. That is the current word. And this is all rapidly changing, of course, as you have probably experienced, as well as I have. Over the last 2 weeks, we've been inundated with information. And information changes pretty rapidly right now, but this is what I'm told for the time being. So DDS is also another agency that you're going to be interacting with. Another agent or office that you're going to be interacting with. Another office you will be interacting with is OHO, the Office of Hearing Operations. Now, if you are in the process, you may eventually have to go appear before an administrative law judge, and that happens at OHO. OHO, like the field offices, have suspended all face-to-face service as of March 17th of 2020. And so you have a due process right, if you have an ALJ hearing, an administrative law judge hearing, to appear in person or by video. That is not going to be possible right now. And they are giving you the option of accepting a telephone hearing. You have the right to decline that and ask that you wait for an in-person hearing or a video hearing when the pandemic settles down and we go back to the normal course of business. But that is your right to decline that phone hearing, and we'll talk more about how the hearings work later as well. So coming back to how to locate your local hearing office, again, going back to SSA's website, if you go to ssa.gov/appeals and then HO locator, you can find the contact numbers for your local hearing offices. Now, I'm assuming my audience should be mostly people living in North Carolina that are involved in this process. And if that's the case, then you are in Region 4, Atlanta, the Atlanta region for your hearing offices. So for instance, I clicked on Region 4. My hearing office I know is in Greensboro. I have the direct line to my hearing office there. And I do know for a fact that the local hearing office workers who are doing telework as well are answering that main number. So you can definitely get in touch with somebody to inquire about the status of your appeal if it's at the hearing level. And you may also be getting a call from them if you have a pending hearing, notifying you that you have the right to consent to a phone hearing or decline that phone hearing as well. Which actually leads to another issue that I wanted to briefly talk about. Right now is a time when, unfortunately, many people will get caught up in scams or be engaged in scams. Social Security may be calling you during this time if you have business with them. That's the only way they can communicate with you. However, Social Security is never going to demand payment from you over the phone. They're never going to harass or force you to do something over the phone. If you get a call from somebody who's purporting to be from the Social Security Administration, and they're asking for your debit card number or asking you to do something involving money right now, like going to get a gift card and mailing it to somebody else, it's a scam, very likely. And on Social Security's main website, SSA.gov, they do have a link about this in red here. What should I do if I get a call claiming there's a problem with my Social Security number or account? Please click on that and read that, and be savvy when you do get a call from somebody claiming they are from the administration. So finally, the other office that you may be dealing with when you're doing business with Social Security is the Appeals Council. And they're always closed to the public. It's an office up in Falls Church, Virginia. They handle appeals from cases that have been denied or sometimes approved by an administrative law judge at the hearing operations level. And the only way to get in touch with them currently is their number, 703-605-8000. So that's the number to get in touch with them if you have any business with the Appeals Council. So before I get into the meat of the presentation about disability benefits, I wanted to go back to the SSA website to tell you what they actually are doing right now, given the COVID epidemic. So again, the only way to get in touch with the field office is by phone. And I'm going to the SSA.gov website. I clicked on coronavirus updates, and they tell us what can be done by phone right now. So a few things. They're doing triage to the extent possible. And so they also want you to know on their website that if you have any questions about the CARES Act, and that's the economic stimulus benefits that many people may be receiving throughout the country, that's not a benefit that's administered by the Social Security Administration. It's actually going to be administered by the Department of Treasury. And they ask you to contact the IRS about any questions involving that issue. So that's not a Social Security question. So Social Security, they are still taking applications for people who are applying for SSI and SSDI. Now, they say on their website that they're trying to prioritize right now people that have terminal illnesses, people that are wounded warriors, people that have certain disabilities that allow for a presumptive allowance of benefits. They're called presumptive benefits, and sometimes also there's a list called compassionate allowances. They're prioritizing those, but they are still processing all SSI and SSDI applications. And you can do that by phone. You can also do some of this online as well, and we'll talk about that in a little bit. They're also trying to prioritize issues related to payments. So if you didn't receive your monthly payment, if you're currently homeless or at risk of being homeless, if you received an overpayment letter and you need to request a reduced repayment schedule or request a waiver, or if your benefit has been suspended and you need to be reinstated, they're trying to prioritize those types of issues right now as well. And again, you can contact your local field office about that. So according to Social Security's releases, what aren't they doing right now? And this is important as well. So what workloads is SSA not doing during the COVID-19 pandemic? Well, they say that if you're currently in the process of what's called a medical continuing disability review, that they are not going to complete or start such reviews right now. Now, this is the official policy statement from the administration. I am not sure at this point, again, this is all very new, how this is playing out at the local level. But if you are involved in a process called a continuing disability review, which at some point we'll talk more about in some detail, Social Security is saying that right now during the COVID-19 pandemic, they're not going to complete such reviews. They also are saying that where possible, they are suspending the processing and collection of overpayments. However, from what I understand, some of the overpayment collection and processing systems are automatic. And so I'm not yet sure how this is going to play out at the local level for some of those automatic processes. So something to be aware of, though, is that in theory, the collection and processing of overpayments is temporarily being suspended during the COVID-19 pandemic. They're not going to be conducting audits of representative payees, and you can bracket that for later as well. So that is some good news. It's some relief for people that may be suffering related to this pandemic. They're going to do their best not to cut you off the benefits right now, according to these policy statements, and they're going to do their best not to collect any overpayments from you during the pandemic. And again, it's yet to be seen how this plays out, though, locally at the local field offices, the local VDSs, and the local hearing offices. So let's go back and talk about Social Security law in general. I think it's important for you as a consumer to know what is the law that's going to guide the decisions that are made about whether or not you should receive benefits or whether or not you get cut off of benefits. And all this information is available to you on the SSA website. So the first piece of law that governs this whole bureaucracy is the Social Security Act. I don't think you need to read the act. Many people probably haven't read the act that even engage in this practice on a day-to-day basis. But that is the piece of legislation that sets up this whole system. And the two parts of the act that we're the most concerned about right now is Title 16, and that's SSI, and Title 2, which includes SSDI. Now, there's something called federal regulations, and this is the agency's interpretation of the act. And the regulations are binding law. They have the force of law. It's how the agency basically implements the overarching framework that the act puts in place. The Social Security Administration has done a pretty good job of writing the regulations in user-friendly language. And if you are curious about the regulations that apply to this whole process, you can find them on SSA's website. So as part of the website, you can go to SSA program rules, SSA.gov/regulations, and you can actually click and go through the regulations themselves. So those are the regulations. In addition, there is something called circuit case law that controls how the administration may act in certain situations. These are cases that people have filed in federal court and eventually had to appeal to a higher level of the court system called the Circuit Court of Appeals. And these decisions that come out of the circuit, and in North Carolina, we're in the Fourth Circuit, are binding on the agency's interpretation of their policy to some extent in our region. I don't know if it's necessary for you as a consumer to read those cases, but I want you to know that it's a source of law when you're interacting with the Social Security Administration. Another source of law is called Social Security rulings. Again, you can find this on that website that I showed you, current program rules, and you'll see a link for the rulings. Now, these rulings, they don't have the force of law. However, they are binding on the administration, including its adjudicators, its judges, and its decision makers. And so you can find some of the rules that may apply to your particular situation, and this will help you get some understanding about how your particular case may play out. The next source of law is really important. It's called the POMS, the Program Operations Manual. This is essentially an employee handbook for Social Security workers about how to do their public service, how to do their jobs. And it's really helpful because when you're interacting with the field office, if you are an informed consumer and you can refer back the field worker to something that may apply to your case, it could be helpful. And it may give you an understanding too about why certain actions are being taken or why certain things have happened in your case. So again, you can find that on that website as well. In addition, on that website, you'll find things called emergency messages and chief ALJ bulletins, and something called the HALIX, the Hearings, Appeals, and Litigation Law Manual. This is the manual that applies to the administrative law judges and how they conduct their hearings within the administration. Again, all this is publicly available. It's relatively user-friendly, and you should definitely review it if you want to be an informed consumer when you're trying to attain or keep your disability benefits. All right, well, SSDI and SSI. Let's talk about, before we talk about what's the same between them, let's talk about the differences. So SSDI, sometimes again referred to as Title II, sometimes referred to as DIB. This is an insurance program. When you're working and you're paying into the system through something called the FICA tax, that's one of the taxes that's taken on your paycheck. You're paying into an insurance system. And after a certain period of time, and it depends also on your age, you become insured within that system. And if you become disabled while you're insured within that system, then you may be entitled to benefits through that system. And the benefit amount that you get, it's called your primary insurance amount, is based on your work history. So that program is not something called means tested. By means tested, it means that they don't look at other sources of income in your family or other resources that you may have. Your benefit amount is what you've essentially what you've earned by working and putting into the system, and it's what you get back out is the insurance amount, and they don't look at other resources. So for Social Security disability insurance, if you get an allowance, if you get approved for your claim, your benefits are payable 5 months after what's called your established onset date. So say Social Security, say you apply for Social Security benefits, 6 months from now you get approved, and they say that you became disabled on June of 2020. You will not start getting your payments actually until 5 months after that date. And you can't get paid back for any retroactive benefits more than 1 year prior to your application date. The other benefit of SSDI benefits is it's linked to Medicare. So 24 months plus the 5-month waiting period after you become eligible for benefits, you will also become entitled to Medicare. So SSI, how is this different? Well, so again, SSI, Supplemental Security Income, Title 16 of the Act, the benefit amount is fixed. The most you can get in North Carolina per month right now is $783 a month. This is called the federal benefit rate. And that rate can be reduced if there is other income or other forms of support within your household. It's a means tested program, meaning it's a need-based program, and only people that have a certain income level and certain resource level are eligible for it financially. That's less than $2,000 in resources for an individual, or $3,000 or less than $3,000 in resources for a couple. And to get SSI benefits, you have to be disabled or 65 plus as well. So one of the other key differences here, though, unlike SSDI, where you can get paid back up to a year prior to your application date, SSI at most can only be paid back to the first of the month after the month that you applied. So say you apply today, April 2nd of 2020, and eventually at some point, a few months from now, you get approved. They will only pay you back if your established onset date is your application date. They will only pay you back to May 1st of 2020. Major benefit, though, of getting SSI is that you also then become entitled to Medicaid. You get medical insurance, and this is a great benefit for many of us, especially right now. So these are some of the differences between the two programs. One is an insurance program, one is a need-based program. What's the same for our purposes between the two programs? Well, it's the definition of disability. So the SSA regulations define disability as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. That's a mouthful. Each of those terms is actually a term of art in some ways. And we're going to break that down so you can understand what it means to be disabled for SSDI and SSI purposes. One of the important things to take into account now is that This is not a short-term disability program. This is a disability program if you have impairments that can be expected to result in death or for at least 12 months or more. So before we break that down, let's talk about how you actually get in the door and apply for these programs. Well, for SSDI, you can actually file online. And in some cases, you can file online for SSI too, but it's fairly limited. So for SSI right now, since you can't go to the field office in person, the only way to apply is by calling the field office directly on those local numbers I told you about. That's how you apply for SSI. SSDI, you can do the same thing. You can apply by calling the field office, but you can do it online, and it's a pretty straightforward process. It's going to be a little bit time consuming, but it's pretty straightforward. Let me take you to their website again. So SSA.gov. I'm going to go to a section of the website called SSA.gov Online Services. And you can do a lot of work here with the administration. And as you can see, one of the things that you can do is apply for retirement benefits through the website, apply for disability benefits through the website, apply for Medicare. You can also appeal your decisions through the website. And you can appeal both SSI and SSDI decisions. So although you can't apply in many circumstances for SSI online, you can actually appeal your SSI decisions online. And in my opinion, if you're capable of doing so, that's the best way to appeal your decisions. Why? Because when you finish the application process, or the appeal process, I mean, you're going to get a receipt, confirmation that your appeal went through. You're going to save that page. You're going to print it out, or you're going to save it as a PDF or some other document on your device or your computer. So that's proof that you actually appealed it. These are crazy times right now. SSA is a big administration. Things get lost. Having proof that you actually appealed it is going to be helpful for you, and also helpful for your customer service representative at SSA if they're trying to make sure that there is an appeal in place. You can say, yes, there is, and I have proof of that in case somehow it gets lost in the system. So you can do all of that through the SSA website. You can appeal a decision. You can apply for SSDI, and in some cases, SSI. All right, well, after you apply, there are certain forms, either electronically or on paper, that you need to fill out. I'm not going to go over all those forms right now. But after you apply, SSA needs to determine whether you meet the non-medical eligibility criteria to even get your claim going forward. So for SSI, they need to determine whether or not you meet the income and resource limits for SSI. For SSDI, they need to determine whether or not you are insured for the period in which you are claiming disability. The insurance dates are a little bit complicated. It's too complicated to go through in a very general presentation like this, but there is something called an insurance period. If you stopped working, say you were insured at a certain point, you stopped working more than 5 years ago, you may have and you became disabled after that, you may have an insurance issue. You should always consult with a representative or an attorney about issues like that. In fact, I recommend, and obviously I'm a little bit biased being a Social Security attorney, but in my opinion, you should probably try your best to consult with an attorney that does this work at any step in this process. So after you are determined to meet the non-medical eligibility criteria, your case then gets sent to DDS, the office that we were talking about before, the Disability Determination Services. And your case gets assigned to an analyst there. And that analyst is going to help you obtain your medical evidence. They may send you to see one of their doctors, an impartial doctor, called a consultative examination. I noted before, because of COVID, it's my understanding right now that's being put on hold. There may be delays in your case right now if your analyst thinks that you need to be sent to a consultative examiner for review. After the evidence comes back to the analyst from your primary care providers and medical specialists and caretakers, and maybe from a consultative examiner, your case gets sent to an internal doctor or psychologist called a medical consultant, and they review the evidence and they give the analyst an opinion about what they think is going on in your case, and then the analysis will make a determination. They'll send your folder back to the local Social Security office, and then you'll get notified. Either you have been approved for disability benefits or you have been denied. And if you have been denied, you'll get something called a notice of disapproved claim. So let's talk about if you do get one of those notices of disapproved claims. Well, there's an appeal process. And if you get denied, you can file something called a request for reconsideration. The request for reconsideration is basically, you're saying, I think this is wrong. I want somebody else to take a look at it. And so what they'll do is they'll do the DDS process again. They'll send it back to a different DDS analyst, to a different medical consultant reviewer. They may obtain additional evidence. And you should be working with the agency to submit your own evidence as well. And we'll talk about the evidence rules in a little bit. And then we'll issue a new decision. Hopefully it will be a favorable decision. You'll be approved. More likely than not, you will be denied again at that stage, and you'll be sent a notice of reconsideration. The reason why I say more likely than not, you'll probably get denied at that stage, because I want to be realistic with you. And I have some numbers up on the slide that I think are important. These numbers are taken from fiscal year 2018. It's called the SSA waterfall chart, and it gives you national statistics about the approval and denial rates at each level of review that we're talking about here. So nationally, this is not these are again not North Carolina numbers, these are national numbers. At the initial stage, only about 35% of cases are approved and 65% of cases are denied. So I'm looking at the chat right now just to make sure. There was a comment, I guess, a few minutes ago that my microphone is too low. So I hope people are able to hear me now. So,
that was about me, Attorney Hogan. So you're okay. Coming through fine. Don't worry,
Great.
We'll keep an eye on the chat and the technical issues.
All right, I appreciate that. Thank you. And I'm not monitoring the chat, Blaine. So if there are questions that should be addressed immediately, please let me know. Otherwise, we'll retain them for the end.
Yeah, we've got some questions, but they look like they are things that we can come back to at the end.
Okay, great. So at the initial level, allowance rate only 35% nationally, and denial rate 65%. At the next level, the reconsideration level, it's a little dismal. Only about 13% of the times in 2018 did they change their decision and grant benefits. 87% of the time, they just basically denied the case again, at least nationally. Here's some good news though. If you get denied there, you can appeal it to appear before an administrative law judge at that OHO office. It's called a request for hearing. And again, repeating myself, I know, but you can do all this online, all these appeals, and you should use the online services if you're capable of doing so. So the numbers are much better when you appear before an administrative law judge. There probably are several factors for that that are probably too complicated to get into. But at the ALJ level, the allowance rate nationally in 2018 was 45%. The denial rate was 35%. The dismissal rate was 21%. Dismissals are probably, unfortunately, maybe people just gave up on their case. Maybe they filed their appeal late. There could be a variety of reasons. But in general, nationally speaking, you have a better chance of getting approved at the ALJ level than you getting denied, just looking at the general numbers. So don't give up hope. If you have a case, you get turned down, keep on appealing it, get before an administrative law judge and argue your case. And hopefully you can have an attorney with you helping you do that. If you get denied at the ALJ level, you have another place that you can appeal to. It's called the Appeals Council. We talked about that place before. It's in Fall Church, Virginia. Numbers there are very dismal. About 1% of the time, in 2018 at least, they said, well, the administrative law judge made a mistake and we think that you are disabled. We're going to reverse that decision and pay you benefits. 85% of the time, they just deny review and more or less basically making, not more or less, for sure, making the ALJ's decision the final decision of the Commissioner of Social Security. However, 10% of the time, they do send it back. The Appeals Council will say, you know what, there are some errors here, either errors of law or the evidence wasn't properly considered. We're going to send this case back down to an administrative law judge for a new hearing to correct those errors. And so you have a second chance to argue your case before a judge. And if you get denied by the appeals council, you then have the right to sue Social Security in federal court, in the federal district court. It's called a complaint for judicial review. And nationally, a lot of times the district court judges and U.S. magistrates, they do find errors in these decisions, and they will send them back down and say, you need to give this person another hearing to correct this issue. But at that point, you're out of the agency, you're out of Social Security, you're actually suing the administration in court. Technically, you could do this without an attorney. My opinion is that you should not. You need an attorney at that stage, for sure. Okay, appeals deadlines. And I'm going to try to wrap up this in about 10 minutes too, because I want to have time for questions. So I might be moving a little bit faster right now. When you get one of these notices from Social Security saying that you've been denied, so notice of disapproved claim, a notice of reconsideration, a notice of cessation of benefits, you're on benefits and they're trying to cut you off, you generally have 60 days to appeal that decision. And they assume that you got the decision within 5 days of the notice itself. So technically you have 65. However, for your purposes, you have 60 days to appeal. Now, in some cases though, so say you're already on benefits and they're cutting you off because they're doing one of these continuing disability reviews, which again, apparently is on hold right now during COVID-19. But say you do get one of these notices right now. If you appeal that notice saying that they're cutting you off of benefits for whatever reason, generally, if you do that within 10 days of receipt of that notice, you can keep your benefits while you are at the next stage of adjudication, next stage of decision making. For people that are involved in medical continuing disability reviews, if you do that within 10 days of the notices, you can continue to get your benefits until you get up before that administrative law judge to argue your case in person or by video, or technically right now by phone, and make your case before that ALJ, and you can keep your benefits while you're doing that, as long as you meet that 10-day deadline. Now, this is important though. Deadlines right now are going to be very hard to meet. You can't go into the local field office. You should still try to meet your deadlines if you can by filing your appeals online, or calling the field office to let them know that you are attempting to file your appeal to possibly just preserve that filing date. But Social Security though has said in their policy updates about COVID-19 that the question is, will SSA extend our deadlines to provide documentation and other information? And then they say, yes, due to COVID-19 pandemic, we are extending deadlines wherever possible. However, I don't know what wherever possible means. I don't know if Social Security frontline workers in the field offices or the hearing offices know what extending deadlines wherever possible means. So do your best to try to get your appeals in still. However, don't risk your health and safety to do so. Try to use a phone system, try to use an online system. And if you can't, there is some hope based on this policy guidance that you may get some reprieve because of COVID-19. But don't use that possibility though to sit on something that needs to be taken care of, like an appeal, as long as you can do so while protecting your health and safety. Evidence in Social Security cases. You have a duty to submit all evidence to a decision maker in your case. So I know we're humans, there's a tendency, if there's something bad out there in our medical records, we may not want the decision maker to see that. Well, unfortunately, you have an obligation to submit all evidence, whether good or bad, that relates to your disability claim, and your attorney or your representative does so as well. So that's something you should be aware of. In addition, when you are appearing before an administrative law judge, if you have evidence that you want her to see, you need to make sure you try to get it to her within 5 business days before the hearing. That's business days before the hearing. Otherwise, she can decline to actually consider that evidence unless you fall under an exception. Of course, right now, maybe one of those times where there's an exception. It may be very hard right now to try to get your medical records from a provider, because our medical providers obviously are focusing on other issues right now. than just medical record ordering. So do your best, though, to get that evidence in 5 business days beforehand, if you have a hearing before an ALJ, otherwise it may not be considered. So we talked before about about the definition of disability, that one statement about what disability means for both programs. Well, what does that really mean in practice? Social Security follows a 5-step evaluation process to try to parse out what that definition means. So there's actually 5.5 steps actually, but they call it the 5-step evaluation process. So the first question that they're going to ask when the ALJ or the analyst is looking at your case is, are you currently engaging in substantial gainful activity? Now, we're not going to go into detail of what substantial gainful activity means, but in general, very generally, and there's always exceptions, but very generally it means, are you working? And if you're working, is it above a certain threshold amount? And I can't remember offhand what it is in 2020. I think it's around $1,200. I can get back to that when I answer questions later. But if you're working and it's above a certain threshold amount, then you don't get to the next steps of the evaluation process. You're just not disabled on the basis of Social Security's rules. If you get past that first question, that first step, because you're not working, you're not engaging in the SGA, the adjudicator is going to try to figure out, well, do you have a severe impairment? Now, this is a de minimis screening device to get rid of cases that don't really have merit. Usually you get past this stage. What it means is, do you have a medically determinable impairment that causes more than minimal limitations in your ability to perform work-related abilities? So for instance, you have degenerative disc disease of your back, it causes you difficulty in walking. Well, you probably have a severe impairment. You get to the next stage. The next stage, though, is a stage that's really important. It's a stage where you can just win your case at. The judge is going to ask, do you meet or equal a listing? You can find the listings on Social Security's website. If you review these criteria, you can see that basically there are certain definitions of disability that if you meet all the criteria, you're automatically disabled. More often than not, claimants are not going to meet the listings. So if you don't worry. You still have a chance of winning your case at the next 2 stages or the 5th stage coming up. But if you do have one of these listing level impairments, then the analysis is done, your case is getting granted, and that's great news. But if you don't meet a listing, then the adjudicator has to determine what's your functional capacity. What's the most that you can do given your impairments? And once they determine your functional capacity, they then will ask, given that functional capacity assessment, given that RFC, do you have the ability to perform your past relevant work? What's past relevant work? It means any work that you've done in the past 15 years in general that was substantial and gainful. So if you have limitations that preclude you from doing your past work, your past relevant work, and well, then you get to the next step, step 5. And here they consider a bunch of factors. They look at your age. They look at your educational level. They look at all those impairments. They look at what skills that you have, and they say, well, what other jobs may exist in the economy that someone with your limitations could do? And if the answer is none, then you win your case. It's a little bit more complicated than that stage, because your age, again, plays a factor. At the age of 50, the rules change. It makes it a little bit easier if you can't do your past relevant work to get granted benefits. At age 55, the rules change again. So it makes it, again, a little bit easier at 55. So that's something to consider too. If you're over the age of 50, your case drastically changes if you have a combination, if you have physical impairments or a combination of physical and mental impairments. So we talked about the listings. I'm not going to go into detail about that. We talked a little bit about functional capacity. I'll leave the slide up here for a second, but I'm not going to go into detail about that right now as well. I will talk a little bit about the components of an RFC. So the adjudicator is going to look at something called exertional limitations and non-exertional limitations. The exertional limitations are your ability to do things like sit, stand, walk, lift, carry, push, and pull. Physical strength demands. Non-exertional limitations, you're going to consider things like, can you bend at the waist? Can you squat? Can you reach and handle objects? Can you finger objects, like using a keyboard? Do you have visual impairments? Do you have communicative limitations? Do you have environmental limitations? Do you have mental health limitations that would preclude you from understanding and remembering information or responding to supervisors, for instance? And they take all these limitations that they can find based on the objective medical evidence and based in part on your testimony or your statements that you have given them or statements from your doctors as well, and they come up with that assessment. We talked about past relevant work. I'm not going to go into detail about that because I want to have time to answer questions. But this slide talks a little bit more about past relevant work and gives you citations to some of the Social Security rulings that may be relevant. So one thing that I do want to flag though, past relevant work, again, work in the last 15 years that you performed that was substantial and gainful, not only how you performed it, but also how it's generally performed in the economy. You have to show that you can't do it as it was generally performed and how you actually performed it. You might want to know, well, how do they know how it's generally performed? There's something called the Dictionary of Occupational Titles. You can find this online as well. That would be something that we can talk about for hours in and of itself. And that's not the point of today either. Step 5, again, this is whether or not there are other jobs in the economy you can do generally based on your age, education, and work experience. And we talked about how the age of 50 and age 55 things change. Those are called the medical vocational guidelines. Again, you can find this on their website. At the age of 50 and 55, again, the rules change, making it slightly easier for people with exertional impairments, those physical impairments, to get granted benefits. Everything we just talked about was about adults. Children can get SSI as well, but the definition for disability for children is different than adults. Obviously, we're not assessing children whether or not they're capable of engaging in work activity. That's not how we're assessing the limitations that a child may have, an 8-year-old child may have. Instead, what we're doing is a different evaluation process. They're looking to see whether or not, first, the child meets any of those listings. And they have a separate set of listings for children that you can find on the website. So if the child meets those exact criteria, then they're disabled. If they don't meet those exact criteria, the judge will ask, well, does their condition medically equal the criteria? And if they don't medically equal the criteria, then they go to the next step, step 4. And that question is important, and that's where most of these cases are decided. They're going to ask if your child is functionally equivalent to the severity of a listed impairment. So what is functional equivalence? They're going to look at your child's domains of functioning in certain areas that they've created: acquiring, using information, attending and completing tasks, interacting and relating with others, caring for oneself, moving about and manipulating objects, health and physical well-being. Those are the areas of the functional domains that they're going to assess. And if your child has marked limitations in 2 of those domains, or an extreme limitation in one of those domains, then they may be disabled for SSI purposes. If you want more information about what these domains are, again, all that's available for you. If you go to the website, you want to look at Social Security rulings from 2009, 2009-1 through 2009-8P. And it will explain to you in pretty easy to read language about what this means. So that's SSI for children. Other issues that come up, and these are primarily for people that are currently on benefits. And this also is where Legal Aid of North Carolina, our attorneys here, do a lot of our work. Continuing disability reviews. Periodically, Social Security, if you're on disability benefits, they're going to look at your case again to say, well, are you still disabled? Or have you medically improved? And they may try to cut you off of benefits. And you have appeal rights, due process rights, where you can appeal those decisions and keep your benefits while you're appealing up until the ALJ level. So if you're involved in one of these CDR cases, feel free to call Legal Aid of North Carolina to see if you're financially eligible for our services and to see if we can assess your case to see if we can help you. Age 18 redetermination. So say you have a child who is getting disability benefits as a child, SSI child benefits. Well, at the age of 18, in most cases, there are exceptions, but at age 18, they're going to reevaluate your child to see if they are now disabled under the adult standard, which is a different standard as we talked about. And if they determine that your child is not disabled under the adult standard, you can appeal that as well. And your child can keep those benefits while you're appealing it through the ALJ level. And that's another area where Legal Aid in North Carolina helps out about. Again, though, in regard to the COVID-19 pandemic, based on the overall guidance given to us from the administration, it appears that they're putting these redeterminations on pause right now. They're not going to complete medical determination for continuing disability reviews right now. Again, I don't know how it's going to play out locally, but if you get one of these, if you do get a denial, you need to appeal it. But you may not have to be worrying about this for the next few weeks, if not months, while this pandemic is playing out, because Social Security is diverting resources to areas where resources need to be diverted to right now. The other issue where Legal Aid in North Carolina is able to sometimes help people out is overpayments. Sometimes Social Security may overpay you benefits because either they were at fault, or maybe you were at fault because you didn't realize something or some other error happened. So sometimes they'll catch an error and they'll say, hey, Miss X, you owe us money back for these particular months when we paid you benefits. You have due process rights for that, for those cases as well, where you can appeal it. You can you can repeal it on its merits. You can say, oh, I think you're wrong. I don't think I was overpaid. And you can appeal the merit of the decision. You can also at the same time say, I also want that overpayment waived because I was not at fault and I can't afford to pay you back. There's a standard for that. And I recommend, again, to consult with an attorney that does that kind of work if you have those types of cases. However, during COVID-19, as you saw before on the SSA website, they said they're going to suspend as best as they can overpayment collection right now. And they still appear to be processing waivers for overpayments as well. And you want to, again, call the local field office, the contact numbers that I showed you before, if you have that issue. All right. That was a lot of material. I highly recommend that you go back and watch the actual video on our website about SSI and SSDI eligibility. It's much more polished than this presentation, and it will give you some helpful information also about how to represent yourself at an ALJ hearing if you can't find an attorney to help you. At this time, though, I'm happy to take general questions. Please, again, though, do not give specific information about you and your issue online. This is being watched by the public right now, so I don't want you to divulge information, and I can't give you specific legal advice about your situation anyways. I'm only giving this clinic to give general advice to the public about these issues.
All right, so with that, I think we will go ahead and move into the question and answer portion. We have a number of questions that have been submitted through chat. Some of them are probably a little bit more specific than we're able to answer in this format, but I'll read them out. And Attorney Hogan, if you're able to provide a general answer, go for it. If not, some of these we may direct you to contact our hotline, because we are still open 100% and accepting cases, as Attorney Hogan mentioned at the beginning. So that may be the answer for a few of these. But we've got a bunch of questions. Let's dive into them. All right. If a father is claiming a child that he is not the biological father, nor is the child in any way akin to him, nor does the child live with him, can you give some direction of what laws are available to assist the parent in notifying SSA that the other child is not receiving their full benefits?
This is a complicated question, actually.
Yeah.
And it's not the type of question I could adequately address kind of in this setting. If this is your situation, though, this is something that I would recommend calling our helpline on. And our helpline workers are very adept at getting information from you that was relevant and helping point you to resources for possibly self-help in this situation, or if warranted, they can send your case, if you're financially eligible and you meet our what's called our priorities, to one of the local offices like me here in Greensboro to actually look at your case in more detail. But I'm sorry, I can't generally answer that. There's too many factors.
Did you have a slide with the hotline number on it? Could you put that back up on the screen?
Yes, I do.
Great. So we're going to put that hotline number back up.
And Blaine, right now I have my chat box up. Does that appear on the slide too?
No, it doesn't cover anything. You're good. All right, so that's the number for the toll-free hotline for legal aid. It's open 8:30 to 4:30 Monday through Friday, and we have evening hours on Mondays and Thursday nights from 8:30 or from 5:30 to 8:30. Excuse me. So, like I said, some of these more specific questions you may be better served by going through that route. So, I've got another one here. Are the slides available for download?
Is that possible, Blaine? I mean, I don't know.
It can be, yeah.
Okay.
I can send out the slides afterwards to everyone who registered through Eventbrite, and then we'll be posting the video and questions and answers, that kind of thing, on our website on the clinic page, and we will make sure it gets up there as well. All right, another question here. How are online? Go ahead.
And again, Blaine, too, I recommend as well that people watch the video that's posted on our website too. If you go to the legal aid website, which I'm showing on my screen right now, you go to the Social Security Disability Clinic list. There's a website that we have posted on, or the video we have posted on YouTube. I watched it last night. It's fantastic, and it has a lot of good information in there. So I recommend that.
And that's the same place. That's the same place we'll be putting things like the slides up. But we'll also send them out to anyone who gave their email address when they registered. Let's see. How are online services more limited for SSI?
Okay, so let me show you how they are more limited, and this will be taken directly from SSA's website. So first off, a child SSI application cannot be filed online. It's just not possible at the current time. Of course, now I'm not going to be able to find that exact information from you. So apply online. Bear with me, okay? So this is directly from SSA. So you can now file for SSI online, but only if you meet certain requirements. So you're eligible to file online for SSI if you're between the ages of 18 and 65. So that means that if you're applying for SSI as a 65 plus year old, so because you're in the quote unquote age category, not because of disability, you can't do that online apparently. But if you're applying for disability between the ages of 18 and 65, you've never been married, you aren't blind, you're a citizen residing in one of the 50 states, DC or the North Mariana Islands, you haven't applied for received SSI benefits in the past, and you're currently applying for SSDI at the same time, then you can apply online. So if you don't meet any of those criteria, then you can't. So it leaves out a lot of possibilities as to why you can't apply online. You can give it a try, but you should be expecting that in a lot of cases, if you're applying for SSI, you're going to be doing that historically in the field office in person. You can't do that right now. You're going to be doing that by calling the local field offices.
All right, we've got another question here. If you have an attorney or representative payee, can they file an appeal for you online?
Well, I know that as an attorney, I can file an appeal for you online. Now, an attorney can't file and sign an application for you. They can help you with the application, but an attorney can't actually sign the application for you, and it has to be from you. But an attorney can appeal it online. I assume, so there's no requirement under Social Security law that your representative be an attorney. So you can actually appoint a family member to be a representative. Now, I don't recommend that. I recommend consulting with somebody that has knowledge about the Social Security disability rules and has been practicing law or practicing this field as an advocate for some time. But you can appoint a family member to be your representative. There's a form for that. For everything that you do with the agency, there's a form for. That form is called SSA 1696. And an appointed representative can file appeals. Yes. Can you file on behalf of somebody if you're not their representative? I doubt it. I just don't know offhand, but I doubt it.
Okay. This appears to be a follow-up to that, I think. How can an attorney file online for the person?
Okay, well, let's walk you through that. So is my screen still showing, Blinn?
Yep.
Okay, SSA.gov online services. So SSA.gov/online services. You want to do appeal a decision. So can you see my mouse pointer where I'm pointing to right now?
We can.
Appeal a decision, you click on that, and then it depends on what stage you're at. So say you got an initial denial, a notice of disapproved claim, well, you can file a request for reconsideration online. Or say you're at the ALJ level. So say you already been denied twice now. You got your request or your notice of reconsideration. Well, you can file an appeal to an ALJ online as well. And say you went before an ALJ and you had an unfavorable decision or a decision that you were unhappy with for whatever reason. Well, you can appeal that to the Appeals Council online as well. So let's just, to play around with this, let's just pick one to see how far you can get in without putting any information in. So say you applied, you got your initial denial, you're still within the time period to appeal. You want to request medical reconsideration. And you can start a new appeal. It's going to tell you what information that you actually need. You're going to want to have that notice in front of you. You want to make sure that you have your social security number, your date of birth, your mailing address, and if applicable, your representative's name, address, and phone number. There's a lot of important, I'm going to call it boilerplate. It's not boilerplate. It's important information that you need to acknowledge and read through. And then it will start asking you some basic information, apparently, about the applicant who's appealing it. You want to put their information in there, or if you're appealing on your own, you put your information in there, and go through the steps. And you make sure that when you get to the final step, everything's been finalized and submitted, that you print out a copy of the receipt that you did submit it. Also, too, something you should be aware of is, say you get a non-medical determination that you want to appeal. So what do I mean by that? Let's see. You get a notice from Social Security. It has nothing to do about cutting you off of benefits for medical purposes or about you applying to get on benefits. It has to do with you get something called a notice of change in payment. They say, hey, we're changing your payment for some reason. We believe that you should not have been paid in January or 2020 for whatever reason. You disagree with that. Well, you can appeal that decision online now as well. So request for reconsideration, you scroll down, request for non-medical reconsideration. So this could be things like you're appealing the merits of a overpayment notice or a decision that they have made at the field office about your living arrangement or about your income. That can be done online as well too now.
Okay. We've got a couple more questions. How many appeals do you get?
Okay. So if you apply and you get denied, you're going to be sent a notice called the Notice of Disapproved Claim. So that's the first decision. And the next step is appealing that, and that's called a reconsideration. You're going to file a request for reconsideration. And if you get denied again, it's called a notice of reconsideration that you're going to receive that will say we're denying your claim. You can then appeal that to an administrative law judge. That's called a request for hearing. So at this point, you're at the third level of decision making. And if the administrative law judge makes a decision that you don't agree with, you can appeal her decision as well to a place called the Appeals Council. And so that's also an agency within the Social Security Administration. So that would be the fourth level of appeal. And then for some decisions, so for instance, a decision that you're no longer disabled for medical reasons or other issues, or a decision that you aren't disabled and you're trying to get on, if you're unhappy with the Appeals Council decision, you can then file a lawsuit at that point against the Social Security Administration, essentially saying that the Social Security Administration did not follow their own rules about how to apply their laws or regulations, or that their decision was not supported by substantial evidence or for other reasons. So in theory, there could be up to 5 levels of appeal. In theory, you can also appeal an unfavorable decision in federal court, take it to a place called the Fourth Circuit. And then sometimes these cases go to the Supreme Court. It's pretty rare, but it has happened for cases that are significant because there's a disagreement in law between the different circuits in the country, or it's an issue of general policy that the Supreme Court finds interesting. But generally, you're going to be appealing within the agency. And so again, reconsideration, request for hearing, appeals counsel, request for review.
Okay. If a person is homeless, what address can they use for communication with the Social Security Administration?
This one is very difficult right now because I understand that a lot of the places that people that are currently houseless were getting their mail at, some of the local resource centers may not be open to the public right now either. So I think this is another reason why in general Social Security is has a general policy statement that they're going to try to be flexible with their deadlines and good cause requirements right now. I don't have a good practical answer for that question right now. You do have to give them a mailing address, and it could be a mailing address, I believe, care of another person. So say you are currently experiencing houselessness and you do have a family member where you can receive mail there. Apparently you can use that address as well. You can change your address online. So on SSA.gov online services again, there's a link for change your address. That's something that you can do online without calling the field office, but you can also call the field office for that reason too, if you need to change your address.
All right. Will SSI individual that worked and filed 2019 taxes qualify for COVID-19 supplement check?
I believe you're referring probably to the CARES Act and the economic stimulus payments. So yes, in most circumstances, as long as you're not being claimed as a dependent, SSI recipients and SSDI recipients are eligible to receive COVID-19 care economic stimulus benefits. I don't know what the shorthand name is for those benefits. Looks like IRS right here is calling it economic impact payments. So this is an area that's changing very rapidly. So it was for a period of time unknown about whether or not SSDI beneficiaries and SSI beneficiaries would need to file a tax return for 2019 in order to receive that benefit. So the Treasury Department, I think just yesterday, released a statement saying that SSDI beneficiaries will automatically get the economic impact payment now. However, they did not address, at least as of yesterday, how SSI recipients will be getting the economic impact payments if they're eligible for them. It was thought at first that SSI recipients may have to file a short form return with the IRS. Nothing's been set up yet, though, as far as I know, with the IRS to do so. Honestly, this could have changed in the last hour and a half that we've been talking, though. I have up before you a page from the IRS, irs.gov/coronavirus. Keep checking this website for information about what you may need to do if you're an SSI beneficiary to try to receive the economic impact payment if you're eligible for it. This is going to be your best resource right now. I imagine that Legal Aid of North Carolina will have some general information up on their website at some point when this becomes more clear. I was on a call yesterday with an advocate in this area, and she said, just take some deep breaths right now, and this is going to be worked out very soon. There's lots of good advocates throughout the country that are trying to address this with the Department of Treasury and SSA and other agencies as we speak. That's all I have for that, but I know this is very important for you out there, and hopefully we can provide more information at Legal Aid about that in the near future.
All right, so I think this is a related question. Can individuals on SSI or SSDI that were working and can't due to COVID-19 apply for unemployment? And I will mention that we've got another one of these coming up next week on employment and unemployment stuff. So if that is better suited to that one, we can recommend that.
That is a really good question. I had not even thought about that. I don't even want to give a speculative answer at this point. Generally my answer is before all the new programs that have been put out in the last week, I would say no, but I would want to consult with our attorneys that are well-versed in the new unemployment emergency payments before giving an answer.
So one of the things we will do is we will pull the chat and the questions that were answered, and we will post them along with the slides and that kind of things on our website in the SSDI clinic, like Brian showed earlier, and we should be able to get an answer to that to include in that posting. Let's see. So this is a follow-up about the representative's ability to file appeals online. Is the process for appointed representative access to e-files at OHO different from that at the level of reconsideration? Referring to SSA.gov/AR.
Yes. So if you are a representative that represents individuals at the ALJ or the Appeals Council level, you can actually get access in real time to your claimant's appeals file. From what I understand, Social Security has been working on offering that service at the reconsideration level as well, but that hasn't been rolled out yet. I imagine there's probably difficulties because the DDSs throughout the country probably have slightly different systems. But if you are at the ALJ level as a representative or an attorney, or the AC level, you can get e-file access. If you go to SSA.gov/AR, there's instructions about how to actually start the process to get e-file access. One issue I see right now is it may be difficult to have follow through on getting that in place right now. Even before COVID-19, it took a while to get authorized to get e-file access. So it's probably not an agency priority right now. But even if you can't get e-file access to the actual appeals file at the ALJ or the Appeals Council level, you can still file your appeals online. And I would encourage you to use the online appeal system.
Okay. Can attorneys get e-file access without taking the test?
Yes. The test that you're referring to is for non-attorney representatives who want to get direct payment of fees, and they have to do a test. However, a non-attorney representative can still get access to the e-files. So say you are a paralegal that works under the supervision of an attorney, and you work on some of these cases at the ALJ or Appeals Council level, you can get e-file access. Again, probably not right now, but you can.
Okay.
And unfortunately, I can't show you.
I'm seeing.
Okay.
Jacob, are you seeing any other questions that I missed?
I just want to reiterate one thing, Blaine.
Go ahead.
Right now is a good time to utilize our helpline if you have issues about public benefits. Again, as I was saying before, this is a rapidly changing area right now. These benefits are really important. Even before a viral pandemic. There's lots of new information out there. We're doing our best to keep on top of it. And our helpline team is amazing, and they will help field your questions. And if it's something that we can actually directly represent you on, they will send it to a local office to see if one of our field attorneys like me can actually help take on the case.
Well, that's actually exactly what I was about to say is call the hotline. We're still open. We're going to be doing more of these sessions in the coming weeks. We have several next week. Check our Facebook page for updates so that you can be aware of what's coming up and come to the ones that are going to interest you. So with that, I think we'll wrap up. Thank you all for coming. Thank you, Attorney Hogan, for your help today. And we will post the questions and the slides and all that stuff will be up tomorrow on the Legal Aid website.
Thank you. Take care. Stay healthy.
Thank you. Bye.